Hi, everybody, and welcome. I'm Leslie with the New Mexico Small Business Development Center, and I'm here with Larry Donahue. He is a practicing attorney here in New Mexico, and he always gives us such great insight on all kinds of different topics. Today, he's going to be presenting on 5 basic steps to dissolve a partnership. I want to remind everyone that the New Mexico Small Business Development Center strongly encourages New Mexico small businesses to learn about the risk to their cybersecurity and take advantage of our pre-recorded on-demand webinars that we have on cybersecurity, and to especially protect your data against ransomware. Also, I would like to invite everyone for any questions throughout this entire webinar. Larry does a great job of picking up the questions and answering them throughout the webinar. So put your questions in to the Q&A and he will pick them up right away. With all that, I'll turn it over to Larry.
Thank you, Leslie. I appreciate it. And hi, everyone. Thank you for joining us. I'm looking forward to this one. And the reason I'm looking forward to it is it's actually a very big deal for most businesses out there at some point in their lives. And it's such a big deal, it's probably responsible for half of my firm's revenue. And what we're really talking about is partnership disputes. So the goal here is to be able to talk about 5 steps and how to unwind a partnership, but I'm making a really huge assumption when I say that. And that assumption is there's no disputes. So if there's a dispute, there's a lot of issues and work around that to deal with those disputes before you can then unwind the partnership. And so I'm going to go into detail on some of that. And today I'm going to give a lot less content, and I'm going to spend some time with examples and stories, horror stories, with some of what I've witnessed in the past, being an attorney for the past 30 years. Before I begin, though, I want to remind you that we have a lot of COVID-related resources. That's still an outstanding and ongoing issue for a lot of folks. And we have a lot of links right here in front of you. If you don't have to write them all down, by the way, you can contact the New Mexico SBDC and they'll give you a copy of this presentation complete with the embedded links and everything. So you don't have to take notes, just sit back, listen, and ask questions. I love questions, and it helps me know that people are paying attention, and also makes for a more interesting seminar. We are going to, put this in a replay series so people will be able to watch it later. With that said, my name is Larry Donahue. I'm a business attorney. I've been an attorney for about 30 years, and I run one of the fastest growing law firms in New Mexico. So what I'm going to talk about is very relevant, and we see this every day. And so it's good that you're here and going to be listening in and participating with us. Before I begin, please mute your audio if you haven't. Fit your Zoom ratio to fit window. If you have that setting, we find that it's the text is a little clearer to read. And then we have the Q&A function. Please take advantage of that and type in as many questions as your fingers will allow, and we'll answer those questions. And you don't really have to worry about the slide number too much. There's not too many slides in this. I'm going to be talking a little more in depth related to what's on the slide. But today's presentation is going to address, what is a partnership? And it's important you understand that. And the importance of a formal agreement with the partnership. And then we'll, of course, discuss the 5 steps needed to dissolve a partnership. That's going to be at the very end before I go into some of my horror stories. So the objectives here would be to better understand what partnerships are and what you need in a partnership agreement to avoid the horror stories. And of course, we got to discuss those horror stories. I do have to give you a disclaimer. I'm a lawyer, but I'm not your lawyer. And while I can give legal advice, the New Mexico SBDC is not a law firm, and they cannot give legal advice. Also, what comes out of my mouth depends greatly on the factual circumstances. I'm going to assume New Mexico law, other states have other rules around some of what I'm going to say. Also, what I say could depend greatly on the facts or circumstances, or whether there's a written agreement, what's in the written agreement. So take what I'm telling you, not necessarily as a grain of salt, but as general advice. And then if you need help, you need to really call a professional, somebody you trust, somebody who is licensed in the state or states that you're doing business. And they will be able to then give you the appropriate and proper advice. With all of that said, let's begin. So the first question is, what is a partnership? And I think a lot of people view this or would answer this differently. And the way I'm answering it is, it's a formal or informal agreement. It could be oral, it could be written between two or more people to conduct business. So it could literally be you and your best friend, or you and your daughter, or you and your father or uncle that are sitting in the same room, or just decide, hey, this is a great idea, let's look into it. The moment you say, let's look into it, you have a partnership, and that would be fairly informal. But there are formal partnerships, and what I define formal partnerships is where there's a partnership agreement or a formal entity structure with appropriate documents. And what that means is the opposite. An informal partnership exists when there's no partnership agreement, or you have a formal entity structure, but without the appropriate documents. So you can have an LLC or corporation, and without the partnership agreements, like for instance, an LLC, if you don't have the operating agreement, then it's an informal partnership with my definition. And I'll explain why that is. But I want you to remember, just because you have an LLC doesn't necessarily mean you've done everything you need to do to avoid some of the horror stories that I'm going to bring up at the end of this presentation. So it's critical not just to have the LLC, but to have a really good operating agreement. And we struggle with this as a law firm because we compete online with a lot of others, and a lot of the others will give a template operating agreement. Well, document A could be really well written, and it's going to be really bad for company A and really good for company B. The point is that even though you might have a well-written document, it has to apply to the factual circumstances in how you do business in order for it to be a good document for you and your business. Now, we're going to go into a little more detail about that and what needs to be in those documents. But before we do, I need you to understand what an ad hoc partnership is. It's really important, and it gets people into a lot of trouble. Basically, remember I mentioned when you and a relative can just decide to do business and basically say, okay, it's time to do, let's do something on your own or together. Boom, you have an ad hoc partnership. So it's basically a informal partnership that forms just simply because you and one or more other people decide to do something in furtherance of a business. It's that simple. You have a partnership just by simply agreeing verbally that this would be a good idea and let's do some research. It's literally that easy. The problem is, once it's formed, it's difficult to formalize it or terminate it if the other partner is unwilling. And you just think about that for a minute. If you want to go your separate way, the other partner can come back and create trouble saying, what do you mean? We had a partnership without definition, without a formal agreement. Is it 50-50? Is it 25-75? Are you the one that has to work all day long, all week long, burning the midnight oil while the other person can just kind of relax and take it easy? Who knows? You don't have it in the agreement. Now, when you hear me say that, think difficult. And when you hear a lawyer say difficult, I want you to hear the words expensive. And likewise, the other way, if it's easy, I want you to think a lot less expensive. And that's really the issue here. Can you eventually prove what the nature of a partnership was? I don't know, can we? Is it your word versus theirs? Do you have texts or voicemails or emails or something that might back you up? That'd certainly help you, but it's hard. And remember what I said, if a lawyer says hard, think very expensive. So if you have a small company, what a great way to kill it, huh? Just by having a fight with a partner who's not producing or doing anything. So we want you to avoid that. The other big issue is when you have an ad hoc partnership, in law, you are responsible personally for the harms and duties and obligations that arise with that partnership. And so that means if your partner goes and does something stupid, let's say they're going to the library to do some research for the company and they drive too fast and get into an accident. Well, guess what? You're on the hook for that accident as much as your partner is. Anything stupid or even negligent or unintentionally that causes harm or damage to others, you're on the hook for. So you really want to be careful with an ad hoc partnership, and you need to be aware of it. So the important piece here is that you need to formalize it. You need to document it and write it down. That document is going to talk about all the specifics relating to the partnership. So if you just have a partnership, and what I mean by that now is it's called a general partnership. A general partnership is simply an agreement between two or more people to do business together. If that's what you agree on, and it's an ad hoc partnership, when you verbalize it and or start doing something, you need to put it down on a piece of paper. So if you agree to, hey, let's look into this company thing, I want you to write down, this is not a partnership right now. We are not agreeing to do business together. We're just going to do some research and get back together. And no partnership is formed until we have a formal relationship. We've agreed to move forward. That would be a general partnership. It requires what's called a partnership agreement. For a limited liability company or LLC, that document is an operating agreement. And we compete with a lot of companies on the internet, and they all say, we give you a template operating agreement. Well, I could tell you, you probably need to throw that document in the trash. And here's why. If you have, an LLC has a number of different tax statuses: disregarded, partnership, S Corp, C Corp. Those are tax statuses. Each one of those tax statuses requires very different language in the operating agreement. Now, here's a test. If you already have an LLC and already have an operating agreement, search for the word capital account. If you have language regarding capital accounts in your operating agreement, that only applies to partnerships. So if you have a disregarded entity or you're taxing yourself as an S Corp or C Corp, your operating agreement is already invalid. There are other issues with operating agreements. You need very different agreements if it's member managed versus manager managed. You need a very different operating agreement if you have a sole member operating agreement versus a multi-member operating agreement. So when somebody says, we'll give you a template, I want you to say, whoop-de-doo, is it going to have all the issues that I need for my partnership, for my relationship with my partner, and does it meet all the other needs that I'm going to need as a business? And if the answer is yes, that's great. That's what you need. Now, there are other types of entities. The other big one is a corporation. And for a corporation, it's a little different. You're going to have bylaws, and bylaws are very high level, very formal. They talk about voting issues and powers of officers. They're not going to discuss relationships between the various shareholders or partners or owners of the corporation. So you're going to want either a shareholder agreement and or a buy-sell agreement. And a buy-sell agreement kind of deals with issues when the company is unwinding, when a partner is leaving. That's what we care about. The dissolving a partnership, what did you agree to and how do you do it? That will be outlined in the buy-sell agreement and or shareholder agreement. And if it's not in the shareholder agreement, then you need a buy-sell agreement. So you need to make it very clear in writing, and I touched on this a little bit ago. When you're talking to people about maybe going into business together, the very first document you need is just a small little on the back of a napkin. No partnership or joint venture exists until a formal document is signed by all the parties. And why do I say by all the parties? I want you to avoid the situation where you sign the document, but your partner hasn't. I've had to deal with a lot of those situations, and they can turn out to be pretty darn ugly. So the document does not exist if there's no partnership, there's no joint venture until everybody is signed on the dotted line. That's what I want you to think about. So what would go into a document like this? Whether we're talking about a general partnership where there's no corporate entity at all, or where we're talking about a limited liability company and its operating agreement, or a corporation with bylaws, a shareholder agreement, and or a buy-sell agreement. Well, the first thing is you want to make sure you have duties and responsibilities of the partners, and we'll talk about what that means in a minute. You also want consequences of not performing duties or breaching the agreement. If somebody doesn't do what they promised they're going to do, what are the consequences? You want to talk about and agree to disassociation and termination events. Disassociation means a partner is no longer a partner. They become disassociated with the partnership or the entity. Termination events mean you can either terminate their partnership or terminate the agreement entirely. What might that look like, and when might that occur? And how does it occur? That's what a dispute resolution process is. If you end up getting in a dispute or fight with your partner, how can you resolve disputes? Hopefully inexpensively and quickly. The last thing you need to be doing is paying us lawyers. And just so you know, I charge $325 an hour. And if I have to go to court, I need a $10,000 or more retainer to represent you. And my fees and my retainer requirements are about middle of the road. You can find lawyers for a lot more expensive and requiring a lot larger retainer. And on the other side, I think some of the newer lawyers, some of the, lawyers that haven't been around very long, I'm seeing billable rates somewhere in the range of, $225 on up. And I'm seeing retainers as low as maybe $3,000–$4,000 on up at a minimum. So do you want to fork over that kind of money just to resolve a dispute with your partner? Or can you follow some sort of mechanism and save yourself a lot of money and heartache? So what would be included in important duties and responsibilities? They will include, and I have a long laundry list here, and I'm going to talk about each one of those here because it's important. One is called duty of loyalty. Does your partner, and do you have a duty of loyalty to the company? What does that mean? It means you need to act in the best interest of the company and not necessarily create conflicts or other issues. Now, it's possible to form a partnership without these in here. So the question is, are they important to you and your business or not? Whatever the answer is, there's no right or wrong answer, but it needs to be written down. I want to see it in the agreement because it's important. We don't want to fight about this later on. If you feel like there's no duty of loyalty to the company and then your partner feels otherwise, you don't want your partner suing you in a year or so saying they were expecting you to be loyal to the company and you weren't. Same thing with non-compete. Do you expect your partner to be able to compete with your company? I would hope not, but non-compete isn't just about when they are a partner. You can also extend it over a period of time. You are working for me, you are my partner, in this company, you're going to be learning a lot of stuff, including who our customers are, who our vendors are, who our important relationships are. I don't want you to compete with me for at least, I'm making up a number here, 3 years. After the 3 years, you go and do whatever you want. But if during the term of the partnership and 3 years afterwards, 5 years afterwards, whatever we think's relevant, you can't compete. That would be a very important clause to put in your partnership agreement. Full-time efforts. I cannot tell you how many people, I come across that end up hiring us because they are burning the midnight oil and their partner is not. Their partner, maybe 3 years ago, they all had other jobs and they were all doing this for fun. And then one of the partners kept doing it while the other partners came over full time. So you have one partner that's still part-time, refusing to come over, refusing to put their full-time energy and efforts into the company. Is that okay? Or is that not okay? Again, there's no right or wrong answer here from a legal standpoint, but there is a right or wrong answer from your standpoint. What is important to you in your business? And remember, it could be used against you as well, right? You could think, hey, I'm joining this company, I'm going to help them out, but I got my other full-time job, I'm only going to help them part-time. They could say, hey, wait a minute, you agreed to eventually come over to us full-time, you haven't been doing so, you're in breach of the agreement, or there is nothing in the agreement at all. So we want to fight about it and hire lawyers. Well, that's a hard thing to fight and defend against. Remember what I said, when the lawyer says hard, think expensive. There are other issues, though, that are important to put in the documents. And the two here are conflicts and nepotism. And so what is a conflict? Well, let's say you have a part ownership interest in a supplier, and then you hire that supplier with this company you're a partnership with. They hire a supplier that you have an ownership interest in. Well, that's a conflict of interest. You could charge a lot of money to your company, the partnership you're in, and make a lot of money and negatively impact your partners. So you want to avoid that as much as you want your partners to avoid that, unless you don't, unless you agree to it. So you need to have language dealing with conflicts and how to avoid those things. And just think of it the other way around. Suppose your partner were to go and buy supplies from another company he owns, or his daughter's company, or a family member's company, and they're exorbitantly high priced or low quality. You want to be able to say, no, that's not right, and you need to deal with that. The other thing is nepotism. I deal with a lot of these issues where a partner will hire family members or friends and literally create a hostile work environment for our client who happens to own the other, 50% of the company. You should be able to have rights to prevent that if that's going to be a problem for you down the road. So another big important thing is what's called a capital call. Now, I'm not saying capital account when I talked about that earlier in my presentation. A capital account is a way to control and take care of the balance sheet between the partners in a tax-related entity for a partnership. Capital call is different. A capital call says, hey, we have 3 partners in our company and we need $75,000 in the company tomorrow. Well, each partner, if they own a third, they should pony up $25,000 each to get to the $75,000 needed that the company needs to use for some reason. That's called a capital call. Guess what? Some partners may be able to have $25,000 sitting around and other partners may not. What do you do in that instance and circumstance? Is it fair that you have to pony up the full $75,000 because your other 2 partners don't have the wherewithal to be able to do that? If so, how does that benefit you? Do you then get a change in ownership? Do you get to kick the other people out? Do you treat that as a loan and get paid back? There's no right or wrong answer here, but I want you to think about the issues and make sure that it's in the documentation, because everything that I'm bringing up here, everything that I'm raising right now, I have been paid lots of money to fight and dispute against, and I would like you not to have that happen to yourself or your company. There's other issues. Let's talk about the disassociation and terminating events. At a minimum, I want you to be able to at least discuss with your partner and put down on paper what happens during a death or incapacity. Does the company just end? Do you buy the ownership interest from the surviving beneficiaries of your partner's estate? Or do you have new partners, whoever those are, the spouse or the children? There's no right or wrong answer here again, but it's good to be able to talk about it. For my firm, I have one partner, and if either one of us dies or becomes incapacitated, we have what's called key man or key life insurance. It's basically a life insurance policy with the company as the beneficiary. So what that means is if I were to die, heaven forbid, later today, the company would get the life insurance, the key man or key person policy paid to the company. They can then use that money to maybe find another, high-level lawyer to come in and help be a partner or manage the firm, or they can use that money to pay off my estate so that my partner would then own 100% of the company. There are other issues though, like voluntary disassociation. What does that mean? Well, let's say you and I have a partnership together and I just decide I don't like you, or you decide you don't like me. One of us wants to leave the company. Is that okay or is that not? Now, I know if you're a reasonable person, you're thinking, oh, sure, anybody should be able to leave the company if they want to. Okay, but what happens when it gets tough? There's debts, outstanding obligations, or somebody needs to do a lot of work to get the company where it needs to go. Is it okay to just leave? Under what circumstances? So if the company's in debt and I want to leave, shouldn't I maybe have to pay my pro rata share of whatever that debt burden is? So you need to think through those issues or edge cases to make sure that you have things set up properly in a voluntary termination. And now you also have to think about it. What does that mean? If you and I are partners and I want to leave, can I take my ownership interest, my 50% of the company, and sell it to somebody else without your permission? You probably don't want that. So you probably want what's called a right of first refusal, the ability to buy my ownership interest before I sell it to somebody else and leave. And similarly, we probably care about the valuation of the company. I'm going to talk about that in a minute. I won't get ahead of myself. But there are other terminating events, such as forced removal or vote to remove. I talked about consequences of breaching the partnership agreement. So if I do something really bad, let's say I compete with the company, or I steal from the company, or let's say I'm a lawyer and I go and commit fraud. And so, it looks really bad for the company. Should the company be able to kick me out? Probably under certain circumstances, absolutely. But I don't want them, hey, we're going to sell the company, we're going to make millions of dollars, and then they kick me out so that they don't have to share those millions of dollars with me. So we need to be a little careful about that, how that language looks and reads, so that we don't have funny business down the road. Finally, there is, valuation issues in formulas and buyout provisions. So, for instance, if I want to voluntarily leave versus I die, I would argue that if I die, my company better pay my estate the fair market value of my ownership interest. Fair market value is, could be a complicated formula depending on the type of business. You may need to hire a valuation expert to figure out what fair market value is. But when you have a firm generating millions of dollars in revenue, it's probably worth it. Now, book value is different than fair market value. Book value basically says, well, what are the assets minus the liabilities? So if I have $1,000 in the bank and I owe $1,000, my book value is zero. Now, a lot of businesses, their book value isn't quite zero. You're going to have maybe some fixtures or inventory or some money in the bank, operating capital. That'll all go towards the positive end of book value, and then minus your liabilities. Usually there's some sort of book value. Now, I would argue if I do something stupid, let's say I just want to voluntarily leave, or I breached the partnership agreement, I should probably be entitled to book value, not fair market value, kind of like a penalty of sorts. If I'm going to go and leave the company and stop contributing, or if I'm going to go and not do what I said I'm going to do, well, then those are my consequences. I can leave or I could get kicked out, but I only get book value versus fair market value for my ownership interest. But everything I'm saying is not a legal requirement. It is just an agreement between the partners. There's no right answer or wrong answer here. What's important is to have the conversation, discuss the edge cases, and then put that down on a piece of paper. So, with everything I just said, let's get to the whole point of this presentation in the first place. What are the 5 steps, basic steps, to dissolve a partnership? Well, the context of this is with the right agreement. If you've gone through the work of having an appropriate partnership agreement, remember, a partnership agreement for a general partnership, an operating agreement for an LLC, or the bylaws, shareholder agreement, and or buy-sell agreement for a corporation. If we've gone through all of that, then we have these 5 steps. And the first one is you review the agreement and you follow the dissolution protocol. You follow the partnership separation protocol, whatever that is. That's what you do. That's how you avoid expensive legal fees and bills. And that's how you keep your wits and your emotional energy with you, is you follow that. 2, you discuss the fact that you want to leave and or dissolve the partnership with your partner. And then you can start talking about the debts, liabilities, obligations, and how to end things. You may find out your partner wants to keep going, and that should be okay if you want to leave. So the question is, how much should you get paid for the company, if anything? If the company owes money, maybe you need to pay money back. You need to discuss those things with your partner and hopefully be on the same page. And I know I have this number 2, and it's kind of a long sentence, but it's probably the hardest thing you can do, is to get you and your partner on the same page as it relates to how you guys are going to split or dissolve the partnership. So assuming you're able to get there and figure out the numbers, and I'll tell you, if you can't agree on numbers, then think about throwing some money at your partner instead of throwing money at the lawyer. The lawyer, sure, we can fight, and oh my Lord, we love a good fight, but we get paid for it and we can never guarantee a result. Versus you throw money at your partner, and if they say, okay, boom, you're done. You get to dissolve and file dissolution of partnership. And it's an announcement that the partnership is formally ending. If you have an LLC, you would submit articles of dissolution to the state, and that's it with an LLC. And there's a little bit more work, but a corporation, that's a nightmare. And a corporation requires you to go and file with New Mexico Tax and Rev and get a certificate of no tax due. There's another step that I'm forgetting off the top of my head. And once you get all of that done, then you can file what's called articles of dissolution for your corporation with the state. So corporations take a little bit more work. But with all of that, you also want a dissolution agreement or separation agreement with your partner, just to kind of outline what it was you guys agreed to in bullet number 2. Part of this, you're going to notify your employees, your customers, landlord if relevant, government agencies, tax agencies about the dissolution and the ending of the company. And if there are any outstanding issues, to where they can go, who they can talk to. Now, the other thing I want to recommend is if you are hiring a third party for your registered agent, I recommend you keep that in New Mexico for up to 6 years, even though the company is dissolved. And the reason I recommend that is we have seen instances where aggressive plaintiffs' lawyers, those are lawyers who sue people, will sue a company that's dissolved as well as the owners, and you don't get the notice because you canceled the registered agent service. And because you don't answer it, a default judgment occurs against you, and then you're stuck. You got a lawsuit out there with a judgment against your defunct company and you personally, and there's no way to fight it anymore. So you do not want a default judgment. And the way you avoid that is by maintaining your registered agent service for 6 years. Why 6 years? Because that's the statute of limitations for written agreements. Once you get past that statute of limitations, I'm a lot less worried about you getting sued individually, although it can still happen. Finally, settle and close everything. The bank accounts, the merchant accounts, pay up those debts, any assets distribute per the agreement you might have with your other partners, or the dissolution protocol that you are following with your formalized business structure. So that's the 5 steps. Super high level, but those are them. Now let's talk about without the right agreement. Let's say you had a partnership and now you're trying to dissolve it, but you don't have a good agreement in place. What do those steps look like? Well, first one is find an attorney to represent you. Second one, fight about the facts that you want to leave or dissolve the partnership with your partner. And here you can listen to the threats from the other partner about your debts, liabilities, and how to end things. It could get very ugly fast. Now, I do recommend you, in number 2, I'm being a little facetious, of course, but you need to find a lawyer and you need to have them advise you on what the law is. If you don't have an agreement in place, there are default statutory legal rules that would guide a general partnership, what I called an ad hoc partnership earlier, or an LLC or a corporation. So you should be aware of what those rules are. And then when you get to step number 2, try not to fight at first. Try to discuss it and see if you guys can come to some sort of agreement on how to dissolve or split up or end the partnership, if at all possible. Now, I find it's 50-50. Really depends a lot on your temperament and your partner's temperament. And it's really hard to predict that until you sit down and have that discussion. But you do need to do that armed with what the law is. And remember that you and your partner can agree on something else. You don't have to follow the legal guidelines or the statutory requirements if you guys agree to something else, as long as both of you or all of you agree. But if you don't agree, then you fall back to the statutory requirements around these issues. 3, if you can't agree and you fight, you're going to spend a lot of money with your lawyer. Be prepared to spend a lot of money. And what do I mean by a lot? I'm going to tell you somewhere in the range of, I've dealt with it as low as $10,000, and we have some fights that have been going on for years, and our clients have spent hundreds of thousands of dollars fighting. Now, it's not just $100,000 with us. We've had to hire forensic accountants. We've had to hire valuation experts, and all of those people cost money. The forensic accountants are as expensive as us lawyers. The valuation expert, not so bad. We're seeing costs anywhere from about $6,000 to maybe $15,000, depending on the type of business and the extent of the assets and the financials of those businesses. Number 4 is you might need to go to court and seek court-ordered judicial intervention in a number of ways. Forcing mediation, obtaining a restraining order. Maybe your partner is holding onto the assets and not letting go, or threatening to sell something or divest something. So you might need a restraining order from a judge to prevent that. There's also judgments, enforcement actions, the court-ordered dissolution, possibly. honestly, getting a judge involved is a very expensive process. You have to submit a complaint with the judge or a motion if you already have a complaint, and you basically ask the judge to rule on something in your favor. Then the other side has 30 days to submit an answer to your complaint or your motion, and that is going to say something like, we disagree, you should not do what they are asking, and oh, by the way, we have the following issues that we would like. And if they have, those are called counterclaims or counter motions. And if they have those, then you have 30 days to respond to those. So just on a simple motion for, let's say, a restraining order or some sort of, motion to compel to provide evidence because the other partner is not providing the books, that could take 60, 90 days just to get all the information to the court. Then the court needs to have a hearing, or they may decide it without a hearing. Who knows? The judge will decide on whether they want to have a hearing or not. And they could issue a answer. They could issue a hearing 30, 60, 90, 120 days from then, depending on the issues. And if they have a hearing, then you got to wait for an answer. And it may come immediately at the hearing. It may take a month or so. So I'm trying to give you a sense of the work and the timeline associated with dealing with the court. So if you're trying to run a business, this is a very emotional and problematic experience. So you really want to avoid that if you can. Finally, number 5, you notify everybody that your company is defunct, and you may need to seek bankruptcy protection to wind up your organization and pay outstanding debts. I hope you see the difference between these two slides is just night and day and creates a huge problem for people. So the real issue here is when you're going into a partnership, spend a little bit of time, money, energy to get the right partnership agreement in place with the right entity structure, ideally, to avoid this slide. With that said, let's talk about some horror stories. I have about, it looks like 18 minutes. And if you guys have any questions, please hit me up with them. But these are real stories that I, the lawyer, have had to deal with before, and they're just heart-wrenching. And I want you to understand them so you know that we don't want this to be you. The first one is the narcissistic partner. And by the way, I'm not a psychologist. This individual may not be a narcissist, but it sure felt like it to me. And they wouldn't negotiate in good faith. And the reason it's really a problem for me is it was my client. So I had the bad client and I was having to deal with this individual. So here's what happened. My client and the partner decided to split ways. More specifically, the partner decided they no longer wanted to be in business with my client. So they said, I'm done, I want out, let's cut the cord. Now the company is generating a little bit of money, not a lot, somewhere in the range of $50,000 annually, but it had a lot of promise, had some good branding, it had some good name recognition. And so my client and the partner couldn't agree on a price to pay to let this guy go. My client was going to take 100% ownership of the company. So my client, by the way, couldn't see fit to call me or email me during the week. This person would call me, I'm not kidding, at 4:50 on Friday and then expect to talk to me for 3 hours over all the stuff that happened the previous week. So that's red flag number 1 for me as a lawyer. But be that as it may, I negotiated a good settlement for my client. The settlement included all the money my client was asking for, as well as work product, as well as a non-compete agreement, and a number of other things that my client asked for. I won it all. And I built and wrote a settlement agreement based on that. So this individual, my client, spent a lot of legal fees with me negotiating a settlement that they asked for, which is very rare. And I developed a settlement agreement and everything needed because the former partner just wanted to leave, and they are willing to do anything to just go. So I got everything all going, and when I got the settlement agreement in place, I sent it to my client to review it and get it back to me. Is this exactly what you wanted? Did I miss anything? Well, guess what? Client calls me at 4:50 on a Friday, yelling at me. Can you believe that? That I misrepresented everything my client wanted. And I pulled up the email that had her bullet list in it of exactly what, she wanted. And she said, I took it out of context, and she sent me a new bullet list, which was a very different offer. She wanted even more money. She wanted even a longer non-compete. She basically was moving the goalpost for a settlement deal. So I have to put my tail between my legs, contact the opposing party, and do you think they want to hear from me again? They thought they were going to be done with this thing. Instead, I got to say, I'm sorry, I must have misunderstood what my client asked for. This is the new terms that they're looking for. And you could bet the other side was really upset about that because they're having to spend more money. They're now in a different position than they were hoping they were. And then they're starting to threaten us, saying we're negotiating in bad faith and they can go to court and get the judge to agree with them. And they might be able to do that actually. It's really, judges don't like people negotiating in bad faith. But I won. That they, instead of them wanting to go to court, they said, fine, change the numbers, change things, we'll agree to it. They wanted out of the partnership that bad. So again, 4:50 on a Friday, the next week or two, I don't remember how long it was, my client again repeated the very same stuff that was repeated previously. I misunderstood. That's not what they wanted. They want this other thing. And by that time, now why are they paying me all the money? Because I can't get it right. And now wanted to go after the partner again and change and move the goalpost again. That's when, of course, I fired the client, and the other side, the other party, didn't get their settlement. They thought they were out of the relationship, and I ended up firing my client because, I got better things to do than deal with somebody who seems to have narcissistic tendencies and act as the bad client. And the deal didn't get done. More expense for all the partners, unfortunately. So I hope you don't have an issue with a narcissistic partner. And I want to tell you, if you feel like your partner, before you're entering into it, exhibits things that you're worried about, it's not going to get better when you join a partnership with them. It's only going to get worse. And you really need to pay attention to those yellow or red flags on people's personalities. It's almost like a marriage, and you want to make sure that you're not going to have a personality conflict down the road, because something like that can happen to you. Let me bring up another horror story, and this one makes me very sad. It's difficult for me to talk about. My client was a 50-50 owner in a company in New Mexico that if I said the name, you'd know who the company was. It was a dynasty. Been around for a long time. My client helped grow it, owned 50% of the company. His partner was a CPA, a certified public accountant, acting as the CFO. Each one of them owned 50%. Well, they were kicking butt for several years, and my client started noticing that it was struggling to pay bills. And my client couldn't understand that. He's like, this makes no sense to me. We're generating this kind of revenue. These are our costs. What the hell's going on? And my client tried to get the financial information from his partner so that he can sort of look at what's going on. My client was the marketing salesperson. His partner was the CFO, the back office person. And his partner, the CPA, kept saying, well, things are a lot more expensive than you think, and you need to get out there and sell more. And my client was saying, sure, but I need to see the financials. His partner refused, so hired me. I had to go in there. I'm literally the proverbial 800-pound bull in a china shop. It's hard for me not to break dishes. And in this particular case, it was important to maintain the long-term relationship of the two partners. So I have to go in there, please, pretty please, and really this is what the law says, but we don't want to be throwing that around. You really need to provide some financials so that we can make effective decisions here and figure out what to do next. So the partner coughs up financials, and the company looks terrible on the books. And I go over it with my client. I have my client hire an independent CPA to look things over. And we as a group look these over. And my client says, some of this is just not right. I know for a fact I sold X, Y, and Z. I know for a fact our rent is this and not that. These financials are just wrong. So I had to get a little more assertive with the other partner saying, hey, look here, these numbers aren't making sense to us. Can you help explain them? And for example, the rent, the numbers here are wrong. Can you please show us, the lease agreements? Well, the partner ends up lawyering up. And the answer to the other side is no, we're not going to give you anything. And basically force us into court. We are forced into court to do a motion to compel for discovery because we don't have the basic information to verify and evaluate the financials. So in court, we hire a forensics accountant, and there's a really good group in town, and they spent a lot of money, and they determined that there was a second set of books, that the CPA partner was literally keeping two different sets of books. And the books we were provided, had thousands and thousands and thousands of dollars devoted to like crazy personal expenses, golf clubs, a pool for the house. There were things coded in the financials that would say computer equipment, keyboard, etc., $2,000 and something dollars. To Kohl's with a K. If you've ever been to Kohl's, they don't sell computer equipment. They sell kitchenware and clothing and cologne and shoes. So the partner would literally use company funds to go and buy clothes, I guess, for the entire family and code it under computer equipment. So this was tens of thousands of dollars. And as we dove in and looked further, we found out that this guy went and got super expensive financing. He was playing a shell game, moving money around all over the place into his personal accounts. It was so hard it was so difficult to figure all of this out. So we went to court, we fought, we sued, and the court sent us to mediation, and we actually reached a settlement. We were going to buy the guy out. And personally, I think we're paying him more than he deserved, but it was important to get the guy out of the business and keep the business running smoothly. So the settlement agreement had a 3-month provision in it where both sides had to do a bunch of things. And at the end of the 3 months, my client would own the business fully and the cheating, stealing partner would be out of the business. Well, within those 3 months, my client died. He had so much stress, he had heart problems, and he died about 1 month into the 3-month settlement window. It was heart-wrenching. Now, remember what I said about family dynasty. He had family and beneficiaries and kids relying on his income and that company. And you know what that partner did? He immediately went back to court and said, the partner died, grabbed the key life insurance, and then fought all over again to kick out the family. So it's a heart-wrenching story here. And at the end of the day, the lesson here is, one, you need to know who your partners are, and they need to be outstanding individuals. But two, you need the right mechanisms in your partnership agreement so that if you have somebody that starts to steal or doesn't provide documentation, you can move on it quickly to make sure that that doesn't turn into a long-term problem for the business. Finally, this one's a little shorter, the disappearing founder. I represent a company out of Arizona. The company was founded by the president and the president's best friend, who happened to be a New Mexico resident. This New Mexico resident, the president of the company's best friend, was independently wealthy, had some sort of like trust, and he used some of that money to help fund the company. And the president of the company was a tech guy. He was going to write software. The friend, the best friend, the New Mexico resident, was a marketing guy. He was going to go and sell. He was going to get funding. He was going to put the collateral together. He was going to do all the non-tech stuff. Well, the company grew to about 40 people. And the New Mexico partner, ex-best friend, at some point decided, I'm not going to work here anymore, and literally just disappeared. Did not respond to emails, didn't do anything. The problem here was the Arizona company is still a tech company without a lot of clients and customers. It had 40 employees trying to build this pretty interesting product, but it needed more funding. Now, in order to get more funding, you have to have all the owners in their agreement, their shareholder agreement said that it had to be unanimous. Every owner had to agree to bring on other owners. That's what happens when you get venture capital funding. So what happened was they needed funding, and this New Mexico ex-best friend wouldn't respond, wouldn't agree to sign anything. So our client had to figure out what to do in this circumstance. And fortunately, they had the ability to kick the guy out. That was permissible under New Mexico law, given the circumstances. So that happened. However, the venture capital group said, that's not good enough for us. We're worried about this guy coming back later. We need something more definite. So we, again, reached out to the guy. We even sent a private investigator to the guy's home and knocking on the door saying, look, for the love of God, can we throw you some money here if you could just sign on the dotted line and let us go, or let the company go on its own way? Nope, wouldn't agree to anything. So our client decided to seek judicial intervention, basically get a judge to weigh in on the ability to kick the person out. So we filed that lawsuit. Then it upset the New Mexico guy. He then filed counterclaims back at the company and then sued the individual other owners of the company. So he turned what could have been just simply a simple signature on a document, and he would have earned tens of thousands of dollars, into a legal, protracted legal battle that ended up costing our client close to $100,000, number one. Two, they lost the VC funding that they're looking for. Guess what? That company now has one employee, the president. They had to let everybody else go, and it's a disaster. The company basically now, for all intents and purposes, ceases to exist, and they can't afford the legal services to continue the lawsuit. So now they're having to defend themselves pro se against this guy who happens to have a little bit of money and a bug up his butt, and he's going after them. And it's a very traumatic situation for everybody involved, including the other owners who are no longer participating in the company. They still have to defend themselves. They still have to hire other lawyers to help them out. So those are the three horror stories. And a lot of this would have been resolved with the right formation documents to deal with some of these issues. And that is the end of my presentation. Do we have any other questions?
Now's the time to ask your questions. And why do I always, every time you have these horror stories, I just kind of cringe, because yes, they are horrifying of what can happen if you don't have the right documents. And I want to remind everyone before we pop off, we have a couple minutes, but we have a whole bunch of webinars coming up. We started off with Larry with the 5 basic steps to dissolve a partnership. We also have Tommy Thompson tomorrow with Cash is King, cash management for your business. We have Eric Spellman, retailers, the most important, should you sell your product online? We have a bilingual session, transitioning to the new normal. We have another bilingual session, accessing financial resources. We have Ian Alden, before you sign your contract, how to examine it. We continue with a new presenter, Peggy McDonough, and she's going to be telling us, are you tax ready? PPP, EIDL grant, and ERTC, which is the Employee Retention Tax Credit, tax implications. So wow, we have a busy week. We hope you attend any of these webinars. Again, they're no cost, and we have the confidential no cost counseling available for anyone that wants information on that. Larry, final words before we say goodbye.
No, other than I appreciate everybody's attendance, and you know, the big thing is to really get the right pieces in place on a partnership and contact the right people. And I'd recommend SBDC as well. They have a lot of great consultants who can help you out and answer some questions to avoid problems in the future.
We do have one question that came in. We can answer that if you'd like to real quickly before we leave today.
The question is, for partners coming together in an LLC, is an operating agreement enough? The answer is yes, as long as the operating agreement is customized for your specific needs in your business. If you have intellectual property, you probably want to talk about what happens with the intellectual property if the individual that produced the intellectual property leaves the company, for example. It needs to be specific to your business and what you and the other partners want. But yes, an operating agreement, a good operating agreement would be sufficient.
Okay, guys, that's the end of our webinar for today, and we will see you next time. Thanks again, Larry. Thanks,
Thank you.
everyone. Have a great week.